Joining me now, Tim Parlatore. He served as Donald Trump's attorney in the special counsel investigations until his resignation in May because of infighting with Trump advisor Boris Epstein. He currently represents, former NYPD Commissioner Bernie Kerik, who turned over thousands of pages of documents to Jack Smith's office as part of the investigation into Trump's efforts to overturn the election. Tim, thanks for joining us on this. Appreciate it. I want to play for you some sound of the former president's attorney who appeared on the Today Show this morning, John Lauro, kind of staging some of the defense it seems like we're going to be hearing in the coming months, and then have you react to the other side. Let's listen.
This indictment is criminalizing conduct, not speech.
No, it's criminalizing speech for this reason. What the president saw in the 2020 election was all these irregularities going on. He had every right to comment on that and act politically. In a criminal case, what they would have to show is all of that speech was not entitled to First Amendment protection.
But we're not talking about
They'll
speech.
They'll never be able to do it.
It's very explicit.
Political
it says, though Jack Smith
speech.
saw that.
Tim, what's your reaction to that?
You know, he's kind of hitting the point that all of these counts do require corrupt intent. They require him to know that these claims of fraud were false and be pushing them anyway. You know, the First Amendment aspect of it is not something that I really see as applicable here, so much as you just focus on what the elements of these crimes are, and the element of corrupt intent, you really laser focus on that, because if he did believe that there was fraud and he was taking these actions based on that good faith belief, then it's not a crime. If in the alternative, as Jack Smith has claimed, he knew that these claims were not true and pushed them anyway, then it could constitute a fraud.
So then what do you make of the conversation that I was just having with Barbara McQuade and Joyce Vance in the last segment, in which the former vice president of the United States sat down in the Oval Office with the former president of the United States and told the former president of the United States that the election was not stolen and that, in fact, he did not have the ability to overturn the results of this election on January 6th, when that election should have been certified. And the president looked at him, the president at the time, and said, "You are too honest." And repeatedly, he was told by his acting attorney general at the time, along with White House counsel as well, that the election was free and fair and there was no fraudulent claims of election that he was making it out to be. What do you make of all of that when you talk about the intent, what the former president knew at the time and what he acted on?
So there's a couple of elements here, and this is what the January 6th committee tried to do. Is they tried to take, certain people told them that there was fraud, other people told them that there weren't, and to then make a judgment call after the fact as to you should have listened to these people, not listened to those people. That's not something that stands up in a criminal case, because they have to really show beyond a reasonable doubt that he knew that there was no fraud, or, as your prior guest mentioned, that there was a conscious avoidance of the truth. But simply having different people that offer differing opinions, you're really going to have to go with a jury and really dive down into exactly what each of these people said, who they are, what he knew about them, what their role was. For example, Rudy Giuliani, who's going to come in and say, "I've been spending 24 hours a day looking at this stuff. This is what we found." Versus, Mike Pence, who's going to sit there and say, "I have no role in any investigations, but I read a couple of things."
It benefits, but Tim,
that's where you have to compare.
I hear what you're saying. It benefits the former vice president of the United States if Donald Trump won this election, right? It benefited members of his cabinet if he were to have win this election. It benefited the acting AG at the time to win this election, the acting deputy AG, the White House counsel, the deputy White House counsel, the Justice Department assistant AG for Office of Legal Counsel. All of these people that told the former president of the United States that the election was not stolen and all of his fraudulent claims were unfounded. It benefited them, but yet they told him this anyway, and he chose not to listen and instead went forward with this scheme.
And that's why it's going to have to go to a jury. And, a jury will be able to assess which one of those people that they believe. You talk about how Mike Pence would have benefited, but yet, the information that we have now is something that Mike Pence apparently has told the special counsel and the grand jury after the fact, after he's already announced that he's running for president against Donald Trump. So he does have something to gain by Donald Trump getting arrested, indicted, and convicted here. So really all of that, you can make arguments on either side, but it does come down to a jury's decision. And because this is a criminal case, not a civil case, it does have to be proven beyond a reasonable doubt. I mean, look, I could see the argument if you sit here and say you ignored all of this other advice, that will work in a civil case where you're talking about a negligence standard here.
Right.
But this is a criminal case where you have to prove knowledge, like actual knowledge and intent beyond a reasonable doubt. It's a very different standard.
Would you want to be on this team right now, Tim? Defending this case?
It's an interesting case to try. I obviously had personal reasons why I stepped away from it. And, you know, if
would you do it?
there would
If he
have to
asked
be
you to do
certain
it, would you
conditions
do
in
it? Or
place
do you
before I would
think,
go back.
do you think the prosecution is too strong at this point? Do you think the case in the 45-page indictment is too strong? Or would you want to be on it?
Just based purely on the case itself, reading the indictment, I do think it's a worthwhile case, you know, to be involved in and to try. If he asked me to join this team, we would have to talk about some other conditions.
Let me just ask you this one final question in talking about timing. Savannah Guthrie talked to the former president's attorney on the Today Show earlier today and asked him about timing. And he said it benefits the defense to have a speedy trial, as Jack Smith wants, but yet maybe we should get 3.5 years because that's what the special counsel got, right? If the former president is innocent here, wouldn't it benefit him to be exonerated on the American stage ahead of the election? Wouldn't that secure votes for him more than anything?
It would, but here's the thing. And I look at this as just an attorney. I'm not involved in the campaign. And so you set aside the election for a second and look at it. In order to get this case to trial within the next 15 months, it would require the defense to waive a lot of significant motions. It would require the defense to essentially not look at the millions of documents that they're going to be produced during discovery. The document discovery in this case is going to be much more extensive than what they had in the Mar-a-Lago case. And there are significant motions that they're going to have to litigate regarding privilege, regarding, you know, the executive privilege, a lot of the things that we dealt with during the grand jury phase. And so really to try and get this case to trial quickly, you'd have to essentially forego a lot of those legal defenses, you know, just to prioritize pre-election trial. And doing that, you increase the likelihood of a conviction, and then from the attorney's perspective, increase the likelihood of malpractice. So I would not advise that at all. You got to set the election aside and just focus on the facts, the evidence, and the law, and just try that case.